Welcome back. There seems to be no end in sight for the gas exploration case. The state and Shell say they are challenging the High Court's ruling that set aside the environmental authorization for the Block 5, 6 and 7 project. The two claim that the ruling was a misapplication of the law. Let's get more reaction now. We're joined by Shahil Singh, who's the legal advisor at the Green Connection. Shahil, good to have you on the program this evening. Firstly, what is the core legal argument behind the High Court's decision to set aside this environmental authorization for offshore drilling in Block 5, 6 and 7?
Hi, good evening. Thanks for having me. So initially, the court had ruled that there were factors that they failed to take into consideration. So these were factors such as failing to consider how small-scale fishers in coastal communities would be affected in the event of an oil spill. There was a failure to consider climate change impacts in relation to future production rights, and there was a failure to consider transboundary impacts such as how our neighbors, in particular Namibia, might be affected by events of a disastrous nature. And there was also a failure to make available to the public documents such as the oil spill and blowout contingency plans. So, what the court found was that these failings were not technical, they were a failure of constitutional duties. So, now, in the bid for to appeal, both the state and Shell are arguing that the law does not require quantifying the economic impact of an oil spill because it is uncertain, and that exploration and production are different legal stages. So, climate change impacts from burning oil or gas should not have been considered yet. They are also arguing that South Africa should not expressly require assessment of cross-border or transboundary impacts. So they are of the opinion that the court should not have read that into the National Environmental Management Act. And lastly, the argument that they're putting forward is that requiring detailed oil spill blowout plans upfront is unrealistic. So that's along the lines of what they're arguing. But it's already established law that uncertainty is simply no excuse for not going ahead and doing the research, doing the hard work.
Yeah, let's go back to that. The state and Shell argue that the court misapplied the law here. What is your response to that claim?
So we're of the opinion that the problem here is that Shell and the state are trying to narrow the protections in our environmental law. For instance, the Constitution guarantees the right to an environment that is not harmful to health or well-being. And we have laws in place like the National Environmental Management Act and the Integrated Coastal Management Act, which give life to these rights. So, in our opinion, the court correctly found that you cannot ignore the socioeconomic risks to small scale fishes. You cannot separate exploration from its obvious goal, which is production. And you cannot ignore impacts to neighboring countries. This is already established in terms of international law, and now with the judgment in place, it's also binding in terms of domestic law because leave to appeal has not been granted as yet. So the court case serves as binding law, so it's now domestic law as well. So we're of the opinion that these are not technicalities. These are constitutional rights, and they're extremely important, and they can't be a box-ticking exercise.
Shahil, why was the lack of public access to updated oil spill and the blowout contingency plans, why was it such a critical issue in this case?
So it was an extremely critical issue because these plans show what would happen or what the plan would be in the event of an oil spill. So something this important absolutely has to be the subject of public scrutiny because if you're a small scale fisher, this is a project that could directly impact your life because they depend on the ocean for their livelihoods. They depend on fishing seasons, and they depend on all sorts of things linked to the ocean. So if you're not sure how an oil spill is going to be dealt with, then you cannot have said to properly have scrutinized the project and properly have been participating and included in the process. So it's extremely important that this information is shown to the public beforehand so that they can see what safeguards are in place and decide if they want to make submissions against the project or not.
Shahil, how does this case highlight the importance of public participation, especially in environmental decision-making?
So, what it actually means for, especially for communities, is that, well, coastal communities especially, is that the ruling is about recognition. The court has affirmed that their rights and livelihoods matter and that oil and gas companies and even the government have to take them seriously in environmental decision making. So it also means that environmental authorizations for these kinds of developments have to be more thorough, they have to be more transparent, and there must be more accountability in place. So it's extremely important in terms of public participation, just as it should be.
But critics do argue that your organization, for instance, is stalling South Africa's economic growth and energy security. How do you respond to those kind of accusations?
So, what we can say is that our constitution makes it clear that development has to be sustainable. It means that there's a balancing act in place between economic activity and environmental protection. And what the judgment does is it ensures that companies cannot cut corners, and neither can the government in terms of pushing ahead for oil and gas developments. Um, we're also trying to push the message that fossil fuel developments are not the only way to have any kind of economic prosperity. There's plenty of clean, renewable energy like wind farms, solar electricity, hydroelectric dams that would all need to be built that could bring economic prosperity because they would need to be run while also bringing South Africa into the future in terms of energy. As it is, we're currently in a just energy transition phase, and we have to start moving away from fossil fuel developments and stop depending on them.
What is your position on balancing economic development with environmental sustainability, especially in the context of energy poverty in South Africa?
So, yes, it's extremely important that everything remains in balance, that we have to balance the environmental sustainability along with our energy development to help ease these demands. We're not blind to the economic impacts or the energy problems in this country, and we're not against development either. All we're saying is that development must be fair and it must be inclusive. For instance, even in our court case, the court respected the autonomy and the authority of the department and the minister because it didn't close the door to the project. It simply remitted the decision back to the decision maker, but put in place safeguards that have to be considered next time. So we feel that the appeal is unnecessary because if the safeguards are followed, and on top of that, there's more public participation, there's no reason that development can't happen, but it must be within the law and it must include all South Africans.
Some industry voices have also labeled the Green Connection and also Natural Justice as Western funded activist groups that undermine local progress. Can you clarify your funding sources and maybe your mission as well, as we try to understand it a bit better?
So, I mean, I can't really go into detail about the funding sources,
Yeah.
but I mean, we get our funding from a variety of places. And the thing is, we're not against people moving ahead and prospering. We just want it to be safe, we want it to be fair, and we want it to be inclusive for all South Africans. And that's really the narrative that we're trying to push here, that we're not against development, and we just want to see South Africa go into a future that's sustainable for everybody, because the truth is fossil fuels are running out, and eventually if we rely on them too much, it's going to create problems in the future, and we have to make the pivot now while we still can.
With Shell and the state seeking leave to appeal this matter, what are your next steps legally and also strategically as well?
So at the moment, the High Court will decide whether to grant leave to appeal. And if that happens, then the appeal would go through and we would have to place our arguments again in the same manner as before. But at the moment, we're still waiting to hear whether that's going to happen or not. So the matter could be heard before a full bench of the High Court, or it could go to the Supreme Court of Appeal. So at the moment, we're still waiting to hear whether that's going to happen because leave to appeal could also be declined. And should that happen, the appellants could apply directly to the Supreme Court of Appeal for leave to appeal. And in the event that they're denied there, it would also be possible for them to petition the Constitutional Court. So at the moment, we're waiting to hear what the court has to say regarding their submissions.
Right. I'd like us to crystallize that aspect. If the appeals are granted and the case does proceed, what outcomes would you consider a win, especially for civil society and affected communities here?
So we consider the judgment in the High Court to be a very strong one and a very good one indeed. So we would consider a win to be similar along the lines of the judgment that we received before, where there's a huge emphasis placed on public participation, transparency, and environmental safeguards, especially in terms of small-scale fishers and coastal communities. So a win for us would indeed be something along those lines. But we feel that the appeal is unnecessary. And for instance, if we look at the state as the appellant in this case, now for South Africans as a whole, especially taxpayers indeed, have to consider this that government receives a lot of its funding from taxpayers. And, this is just a waste of resources because if the department abides by the High Court rulings guidelines in terms of what needs to be done, then there wouldn't need to be an appeal in the first place. And to be honest, we shouldn't have had to resort to going to court to begin with, indeed.
Yeah. And what message, as we wrap, do you have, especially for coastal communities and small-scale fishers who are directly impacted by these decisions?
So, for coastal communities in particular, but even just for other ordinary South Africans, this ruling is about recognition. The court has affirmed that their rights and livelihoods matter and that oil and gas companies and even the government have to take them seriously in terms of environmental decision making. It also means that for future environmental authorizations, the decisions have to be more thorough, they have to be more transparent, and there must be more accountability in place. So, really, the judgment is all about recognition, showing that these people, these vulnerable people, can't be sidestepped or overlooked.
Yeah. As the legal battle over Block 5, 6, and 7 continues to unfold, South Africa once again finds itself at the crossroads between development and environmental justice. While the High Court ruling stands for now, the voices on both sides of this case reflects a broader national debate. How do we secure our energy future without compromising our people, our environment, but also our constitutional values? A big thank you to Shahil, our guest, for shedding light on this complex and vital issue as well.